holidays in 2022 was all about what do you do before there is a claim to protect yourself. Risk mitigation, things like insurance. What kinds of insurance are out there? What do you do? How do you interact with your insurance agent? And how do you deal with an insurance policy? What kind of policies and procedures can your company put in place proactively and in advance to make sure that you have safeguards so that your company or your business is protected in the case a claim arises? All of those things I think were really helpful because most of the time your business is not going to find itself in litigation, hopefully. We're litigators, we're business litigators, so obviously that's our focus, and that's going to be the focus of the webinar series here. But I think those were really helpful because good planning is really the first step in avoiding the real downsides of litigation. But today is really what happens next. What happens when there is a claim? When you get a notification that something has gone wrong, what should you do? How should you respond? How should you investigate? Who should you get involved? And I think that's really what we're going to be talking about today. So even before we get started into the substance of each of those things, it's important to understand how claims and lawsuits arise. Where are these things coming from, and really what they mean for your business. So claims or lawsuits generally arise where there is a legal duty of some kind that one party feels has been breached or violated or not fulfilled. And there are lots of ways those duties could arise. They could be contractual. Most businesses enter into contracts with other counterparties for the delivery of products, the provision of services, for all kinds of things, including legal services. There could be a contractual duty that includes a promise to do something or not to do something that you feel the other side has not done, and that can give rise to a claim and eventually into a lawsuit. It could be something that has to do with the relationship between your business and your customers. If you have a physical location, it could be that somebody slips and falls, and all of a sudden you find yourself in a situation where there's a tort claim based on that. It could also be amongst the business owners, right? So it's not always outsiders that are part of these kinds of disputes. It could be that one shareholder believes another shareholder has done something wrong, or that an owner has breached their fiduciary duties in a closed corporation. That's another place where there's a duty where somebody might feel that they have been wronged and that there is a need to get lawyers involved to make a claim, to bring a lawsuit. And it also could be statutory. If you are a business in a regulated industry, and if you are, you likely know that, but I mean, it could be everything from insurance companies all the way up to real estate agents, all the way up to construction companies that are dealing in the right kinds of projects, all have statutory obligations that they need to deal with, and oversight from government bodies that may find that there is a need for a claim or an enforcement action based on those sorts of legal duties. So the idea is that the idea of today's webinar is, what do you do when the claim arises? And before you even get there, you have to ask, how are you learning about these claims? And most of today's webinar is going to be about the defense side, but I do think it's important briefly to talk about the plaintiff's side. If you are the claimant, how are you finding out that these things are happening? Because there are lots of ways that you may find that you have been wronged and that there's a need for you to bring a claim. So, for example, if you were expecting a delivery of a piece of equipment that didn't arrive on time, or you think that one of your customers has stolen your trade secret, or one of your employees has stolen your trade secrets and customer lists, you may have a claim against that person. You should have policies and procedures, like we talked about last time, in place so that your people, your employees, know what to look for and what to do in the case that a claim arises. And that applies equally to the defense side. You want to make sure that your people on the front lines, if your business is more than just you, you want to make sure that the people that are working with you and for you know what to do as soon as they sense that there's a claim in either direction, either where you are the claimant and that you feel like you have been wronged, or that you are the party that's receiving the demand. So really, there are three ways I think that Now, you can learn that a claim would arise from the defense perspective. Um, One of the most obvious is that there's a lawsuit that's filed against you. There's a complaint that gets filed in court. It gets served by a sheriff or by a professional process server. And through that complaint, you learn, sometimes bare bones, but sometimes detailed allegations about what they think happened and what claims they think, what counts they are asserting. It may also come from a demand letter where a person or a person's representative, like a lawyer, sends a letter that does the same thing, but often with more of an eye towards avoiding litigation. Right? Once you're in litigation, it's harder to get out of it. Um, Demand letters are a good way to try to nip that in the bud and deal with the claim outside of the court system. In addition to that, it may happen just organically through your business. You may find that your employees understand that something has gone wrong, um, and they alert you to that prospectively before there's outreach from the other side. Somebody tells their manager, "Look, we dropped the ball here. We should get ready." Um, so that informal reporting, I think, is an important part also. Um, so once you learn there's a claim, what do you do next? And that's what I'm going to turn it over to Mike to talk about. What do you do? Who do you talk to first? And then what do you do next? So one of the first things is insurance, and I'm going to have Mike talk about that now.
Like Alex said, that this discussion of claims and lawsuits does encompass whether you are bringing a claim or lawsuit as the plaintiff or prosecuting party, or you are defending against a claim or lawsuit that you're receiving from another person or entity. But specifically on the defense side, a key first step in responding to that claim or lawsuit is to inform your insurance company. Um, because the insurance company is in place, you pay the premium, and the goal is to provide prompt notice to your insurer so that they may make a coverage assessment to see if that claim or lawsuit is covered within the policy that you purchased from them, and that insurance company may be able to provide your company with the defense to that claim or lawsuit, which would include reimbursement or payment of all defense costs, which, as we can see and based on our experience, can rack up in litigation. And so, being able to have an insurance company that can defend and pay your defense costs is a key portion of protecting your company's interests. Not to get too much into the weeds about insurance policies, but there is a distinction between policies that are claims-based and occurrence-based. A claims-based policy typically requires a company to provide notice of a claim or a lawsuit within that policy period. There can also be different provisions depending on the specific language in the policy about a specific time period when you have to notify the insurer after receiving notice of a claim or lawsuit, or there can be this prompt notice requirement that's set forth in your policy. But most important, it's key to be familiar with the language of your policy and to contact your broker or agent so that you're familiar with any sort of requirements that you have to fulfill in order to provide that prompt notice as a first step after receiving notice of a claim or lawsuit. But I think a good strategy or approach from the outset is to provide prompt notice to your insurer as soon as reasonably possible after receiving word about a claim or lawsuit against your company. So that kind of covers the when of informing your insurer. In terms of the how does a company properly notify their insurance company? We're always going to recommend that notice is provided in writing, just that you paper that trail, that you document it, that you're able to show down the line if any issue or discrepancy arises, that you can point to particular correspondence saying, company X provided notice to insurer Y on X date. And then lastly, but perhaps most importantly, the why of why a business should inform its insurer promptly after receiving notice of a claim or lawsuit is that oftentimes insurance companies will dictate their response and their decision on whether to cover your business and defend it in a lawsuit depending on whether they receive prompt and reasonable notice of a claim. And Massachusetts law actually mandates that the notice requirements in an insurance policy are strictly enforced, that they look to the language of the policy and they uphold those terms, and that a company's failure to comply with their insurance company's um, notice requirements may bar coverage for that claim or lawsuit. And there's no requirement that an insurance company is prejudiced by late or delayed notice of the claim or lawsuit. A notable example of this in practice and in reality was a recent decision from the Federal District Court in Boston that arose from Harvard University seeking coverage and reimbursement for its defense and appellate and legal fees for the affirmative action appeal that is presently pending before the U.S. Supreme Court regarding the university's admission policies. Harvard tendered coverage to Zurich, its insurer, seeking reimbursement of roughly $15 million in insurance fees. But the issue was that Harvard notified Zurich of that issue and its request for coverage beyond the claim policy period. And so the court looked at this issue and said, Harvard was unfortunately out of luck and that they were on the hook for those $15 million in legal fees solely because they failed to promptly notify Zurich of the issue of this claim, this lawsuit, this ongoing case. And any arguments about, well, this was a high profile case that was in the news, Zurich could receive constructive notice of that. The courts said, we look to the strict language in that policy and they interpret that as such. And so that's an indication of how courts will be pretty ruthless or no nonsense in construing the terms of an insurance policy on that notice provision. And so that may be an extreme and noteworthy example. It does show the importance of prompt notice to your insurer and strict compliance with any specific requirements of your insurance policy to get that notice in writing out the door to your insurance company as soon as reasonably possible after you receive that notice of a claim or lawsuit. And now for the next step in this response period for your business, Alex is going to talk about other folks or individuals that should also receive notice of the claim against your business.
Yeah, I was just going to add also to the insurance piece that part of the reason you want to get your insurer involved early is that they may try to decline coverage, and there may be a period in which you are fighting with your insurance company to get coverage that doesn't necessarily coincide with the pace of the dispute. So it may be that you're ready to negotiate, ready to settle, ready to respond to the claim, but you're still waiting for the insurance company. Part of I think the strategy of getting those notices into the insurance company early is so that you can get their response early. You want to give them whatever documents they're looking for early because I've been in this position. I'm in this position right now where you're months into the case and you're still fighting with the insurance company at the same time you're trying to get the case to mediation. Mm-hmm. That puts you in an awkward position where the insurance company, because for better or worse, oftentimes tries not to pay. They're dragging their feet while you're trying to move things forward quickly. You're trying to get to a fast resolution because that's best for your client, the insured. You want to move quickly with the insurance company for that reason.
And even if it's the insurance issue is very important, but like you said, it can detract from pursuing the substantive aspects of the case moving forward and wanting to press it ahead to a favorable resolution. But if you're going back and forth with kind of a feisty insurance company, that's going to be a distraction and additional costs to the business if you don't kind of nip that issue in the bud from the outset.
Exactly. And another piece of the insurance communication about a claim is that they're going to be doing an investigation and they're going to help inform your own investigation, which is something I know we're going to talk about in a minute. But I think it's important that you rely on their expertise and what's important, what you need to know, what you should be looking for, and all that stuff happens with early notification of the claims. But insurers aren't the only people that may provide indemnity. So the idea of indemnity with an insurance company is really that you're looking to them to help reimburse the costs and losses from the claim or the dispute that you're dealing with on the claim side. But insurance companies, although their business really is defense and indemnification, they're not the only party that you should consider as a potential indemnitor for your claims. There may be contractual indemnification. We see that all the time in construction contracts, but also in business contracts. So in the construction context, there's very often indemnification provisions amongst the general contractors and the subs and vendors, the owners and all their contractors, because really it's a tool for allocating risk in advance. And if you have negotiated your contract in a way that you can look to somebody else to bear that risk instead of you, um, you should take advantage of that provision. It was part of what went into the terms of the agreement. It likely affected the pricing of the agreement, and this is the time that it comes into play. You don't want to leave that value on the table by forgetting to look at your contract and seeing, even if you didn't look carefully in the first place, who can I try to put this claim on in addition to or instead of me? Um, and we see that also in other businesses as well. So in real estate agreements between a landlord and a tenant, who's responsible for clearing the paths if there's a slip and fall. We see that in all kinds of other business contexts where there is an agreement, like I've been mentioning, delivery of a piece of equipment. What happens if that's late? Who's going to bear the cost of those delay damages? And that's something that could have been included early on in your negotiating process. That really is indemnification, much like an insurance company, but as between two private businesses. And so as a result, the same principles that Mike was just talking about apply equally when you're dealing with non-insurance indemnity provisions. So you want to get your claims in early. You want to give the indemnitor sufficient notice of what the claim is, the facts, the exposure, so that they can investigate themselves and evaluate and participate really in the claims handling process, even if it's not an insurance company and even if that's not their business. You want to make sure that you're not risking any kind of waiver by not bringing those people in early and fully and making decisions without them if that's something that you need to do based on what the provision requires. And oftentimes in a contract, it'll describe precisely what kind of notice is required. I've seen cases where two big sophisticated companies have mutual indemnification provisions, and one fails to give notice. And if you don't give notice, your claim is waived. And the contract very specifically describes what would suffice as notice. When does it need to be given? What is a claim? And if you fail to comply, just like an insurance contract, you can end up waiving those claims even amongst private businesses. So you want to get those indemnitors, indemnity provisions activated in the same way with an insurance company. But then once that happens, you want to start investigating. And I'm going to turn over to Mike to talk about sort of the document part of that, because it's an important piece.
Right, right. So once your company receives notice of a claim or lawsuit, a common tactic used in these cases or claims is a preservation of evidence letter or a litigation hold letter. Those terms can be used synonymously. But when your company receives one of these letters, it basically spells out specific categories of documents or other pieces of information that the adverse party thinks that you or your company is in possession of that would be relevant to the issues related in that case or lawsuit, and they are putting you on notice and saying, preserve these documents because we're going to want to access, request, look at those throughout the case and see how they impact, the various counts, claims in that case moving forward. And a key portion of upon receiving this letter is to make sure to distribute it amongst the folks in your company that have access to documents, that have the ability to destroy or lose documents, and to convey very clearly and strongly that you have to retain put in place systems to retain those documents so that, inadvertently or on purpose, that those documents, that evidence is not lost when that adverse party, presumably down the line in the case, comes knocking at your door, says, hey, these documents we requested. We previously sent you a letter saying, preserve, hold on to this information. Where are they? And it's a difficult situation in litigation when a party, after receiving notice of a claim or lawsuit, after receiving a litigation hold letter, then finds out or has to communicate to the other side that unfortunately we don't have that information. That could lead to a broad array of sanctions in the case itself, and I don't want to get too down in the weeds with that today, but one of those could be an adverse inference against your company if your case does end up going to trial. Say if the litigation hold letter requested, emails pertaining to this certain subject matter in a case, and you get up in the courtroom, the counsel for the other party says we sent notice to retain these emails regarding to this specific subset of your case. Because those emails are no longer there, the company did not comply with the litigation hold letter. Jury, you can infer that the contents of those emails that the company does not possess has contents that are harmful to that company's case. And so that's obviously a situation that we want to avoid. That's going to be months and years after receiving initial notice of a claim or lawsuit, but that further speaks to the fact that your ability to protect your interest and defend against a lawsuit really does start from day one when you receive notice of that claim, of a litigation hold letter, that you really start, devising your strategy in concert with your counsel to make sure that you're in the best position moving forward. And I guess something that our firm often recommends to our clients is to have in place some form of document retention policy in place of the company that's communicated to the various employees to make sure that systems are in place that upon receiving a litigation hold letter, that systems are in place to make sure that all those documents are retained and don't slip through the cracks, something that they are available moving forward.
Yeah, and I think strategically there's also upside to having those kinds of document retention policies in place and a litigation hold is that documents aren't necessarily bad, right? So even if you're on the defense side, you don't want to just save the documents because the other side might look for them because they want them. You may want them, right? There may be exculpatory emails, contract drafts that are helpful to you. Those are all things that you might want to find yourself later. And just as a practical matter, during the litigation process, there's a tremendous amount of posturing that happens. And as soon as you start putting yourself in the position of being the less responsive, the less responsible party, even in terms of just participating in the claims process, you're going to look, you're going to be put in a position of defense, which you don't want to be. Right? You don't want to be dealing with in the letter writing campaign leading up to a lawsuit after there's a claim, dealing with allegations that you've destroyed documents, that you don't have documents, because it just puts a black mark on everything you're doing, sometimes unnecessarily. So it's an important thing to remember.
Yeah, it's going to uphold your credibility
Yeah.
with opposing counsel, with the other party, with the court, and it's just a headache that you want to avoid and to focus on, the main case strategy.
Yeah. So once the claim arises and you've been notified of it, and you've then notified the people outside of your company that should know about it early, indemnitors that may be contractual, part of it, contractual indemnity provision, or your insurance company, the next thing you want to do is start looking internally. Do an investigation, because one of the most important things you can do in the very beginning of the case, in addition to making sure that you keep the documents and keep the evidence, is look for the information that you're going to need to defend that claim. So you're going to want to start doing an investigation into what the claim alleges. And there are lots of reasons that you might want to do that. One is because you want to understand what the claim is. Another is that you want to be preparing a defense. But in addition to that, you're a business. You want to be a going concern long into the future. You want to make sure that you're learning from the claims that are arising, how to do your business better. What lessons can you learn? What best practices can you pull from this so that this doesn't happen again? In addition to that, you may have sort of a need to report these kinds of issues up to regulators. You may have a need to report them to shareholders or investors. There are lots of reasons that you're going to want to investigate the claims, not just so that you can respond and defend yourself, but because it's part of a holistic approach to dealing with problems in your business, just like you would if there was an unhappy customer. You want to make sure that you're thinking about what can I do as a response to this particular claim or lawsuit that I can learn um, one, how to defend myself here, but more broadly how to improve my business. Um, an important part of that investigation process, though, is almost always going to involve a lawyer. And it's important, right? I mean, it's important that you bring your lawyers in early, just like with your insurance company. And frankly, you should get your lawyer involved even before your insurance company or indemnitor, because they're going to be able to help you navigate that road. They're going to help you uh, understand what the claims are, what the exposure is, what the strategy would be for responding to it. But part of dealing with a lawyer always, particularly if it's a claim that involves multiple people within your business, is ensuring that you're protecting the attorney-client privilege. And it comes up a lot in investigations early on in claims because all of a sudden people that don't typically deal with the company's lawyers are interfacing with lawyers. They're talking to in-house counsel, they're talking to outside counsel about their work, about their communications. They may not know the importance of maintaining the attorney-client privilege. So it's important that you explain, or your lawyers explain to the people that all of a sudden have found themselves thrust into this claims process, that the attorney-client privilege is very fragile. As soon as it goes outside of the attorney-client relationship, it's no longer privileged. And you can, if you're not careful, waive that privilege by sharing it too far afield, even within the company, where if people that don't really need to know and aren't really involved in the investigation or aren't really involved in the claim are hearing about this particular issue and hearing communications that are coming from your lawyer, you might find that the privilege has been waived and that you no longer have it. But in addition to that, you want to make sure that you're keeping these things confidential for other reasons in addition to just the privilege. You don't want people that don't need to know about the claim because that's going to result in people talking about it, gossiping about it. Um, and a lesson for everybody really is don't don't put in writing your thoughts and feelings and opinions of the case. Nothing good comes from that kind of that kind of dissemination. I'm mindful of the time. We're running low on time here, Mike. So
Yeah, and so I know that we talked about those first steps in responding to a claim or lawsuit, and as you move forward in that, there are specific court rules that are in place, whether you're in state and federal court. And I know that later editions of our business litigation webinar series are going to cover those more in depth. So we do urge you to tune into those and to keep an eye out on our YouTube page and our LinkedIn pages for when those webinars are scheduled. But as Alex was saying, that a key part of this initial process is to consider retaining experienced business litigators because in our experience, when a business receives notice of a claim or lawsuit, that might be the first time they're ever dealing in this type of process, and it's foreign to them. Whereas, this is an area that we have that experience with, that there are, protocols, strategies in place that we've used with success in the past. And while every case has its own unique set of facts and actors that we are positioned to work collaboratively with businesses to make sure that from the outset, from first receiving notice of the claim or lawsuit, to position your company in the best position to navigate this, arduous, can be time consuming, costly, to navigate your business to a favorable and prompt resolution. And so, we do urge, consideration of retention of experienced business litigators to make that process run as smoothly and effectively as possible.
yeah, so thanks very much, Mike. I appreciated all the input that you gave it here, and I hope you all tune in for the next webinar.
Thanks, Alex.
All right, thank you.